little bit, yes. Sorry. Trying to wake everyone up. Yes, sorry, apologize.
It might work.
All right. I believe that we will now begin. So thank you all for coming to our event today on the Google versus Oracle case, officially titled Consequences of the Case. I actually have my own subtitle, which is Copyright in the Future of the Software Industry. It's a very significant case, and absolutely delighted to have Tim Wilson, Director of Patents at SAS Institute, to speak to us today about the relevant legal and policy and commercial issues that are raised by this case. My name is Adam Mossoff. I'm a senior fellow at the Hudson Institute, and I'm also now the chair of the newly constituted Forum for Intellectual Property at the Hudson Institute. This is, in fact, our inaugural event, and so we're absolutely delighted to have it on such an important issue and with such a great speaker. The Forum for Intellectual Property will be hosting events and sponsoring and promoting data-driven, fact-based research that explores and investigates the importance and key role that intellectual property plays in not just driving the US innovation economy for the past 230 years, but all innovation economies throughout the world, creating the foundation for flourishing societies. And we hope very much to play an active role in ensuring that fact-based research and data-driven studies are in the hands of our policymakers as they consider the very important issues, such as the decisions that have to be made in important cases at the Supreme Court and legislation that has to be considered before Congress and regulations that will be adopted by our agencies. So as I mentioned, I'm very delighted to have as our speaker today Tim Wilson, Director of Patents at the SAS Institute. I would like to just to emphasize that we are both speaking in our individual capacities only and not on behalf of our respective institutions. Normally, I do not give large or long introductions of people. If you wish to discover all of Mr. Wilson's incredible accolades and achievements over his multi-decade career, embrace our mobile revolution. Choose the browser of your choice, the search engine of your choice, whether Bing or Google, and you can find all that you wish about Tim Wilson. But thank you, Tim, for being here today.
My pleasure, thank you.
All right, so I want to kick off our discussion before we start talking about the Google v. Oracle case. Many people may not have heard of the SAS Institute and may be wondering, what is this organization and why are you talking about this case from the perspective of your work at the SAS Institute? So could you please tell us a little bit about your company?
Sure. SAS is a large privately held software company in Cary, North Carolina, which is about an hour flight south of here. And we have been in the software business since before there really was a software business. Back in 1976, we were founded, but actually have our roots going back into the 60s. And the problem that SAS was trying to solve was to determine, patterns in data that you couldn't see with the human eye or people couldn't perceive, statistics, analytics, artificial intelligence, all of those things are things that SAS is kind of best at developing. And so we have about 14,000 employees around the world now. We are, like I said, a large software company. We call it a proprietary software company. So that is a company that we actually make money directly from our software, and our customers are happy to participate with us, and it helps us develop our software going forward. Also, kind of interestingly, apropos about this case, is that we have a API, what's known as an API today, that is the main way that our software is interacted with by our users. And so they create programs, and that tells the computer kind of what to do. And it's very useful to have those APIs be easy to understand and use by our users. And that has really been one of the major reasons that SAS has been very successful at becoming a big software company, and one of the reasons this case is very important.
Excellent. And the case centers around an API. For the non-tech geeks in the audience who may be watching this via live stream, API stands for?
Application Program Interface. So what it actually means, I think, in a technical sense, is it kind of is shorthand ways to refer to and access big blocks of computer code. Any of the kind of programmers in the audience might know the various generations of software has been kind of first generation systems, second generation systems, third generation systems. APIs really are kind of the referred to as the fourth generation system, where we're not actually directly programming in a programming language like C, but we're programming the systems in big blocks of code. And so it's really an important and modern way to interact with the code.
All right. I'm sure we'll dig into some more of these details in our opening remarks. We're going to have a moderated back and forth between us to kind of lay the foundations of what the case is about and some of the policy issues, and then we'll open it up to questions from the audience in about 20 or 30 minutes. So March 24th, the Supreme Court will be hearing oral arguments in what is now styled Google versus Oracle. It began actually as Oracle versus Google back in 2011 when Oracle first sued Google for copyright infringement. Now the case is really centered around the rise of this little device that I held up. I used to refer to this as my infringing device when I would talk at patent conferences, because it's the Samsung Android device that was sued by Apple, and now I can refer to it as my infringing device because of the Oracle versus Google case as well. So it's in multiple levels of infringement. So can you give us some of the relevant background here to the case and why I'm making these references onto my smartphone?
Sure, awesome. So back in the 1990s, Java was kind of created by Sun Microsystems as a new, very popular software development programming system. And Sun was later sold to Oracle, and so that's how we got kind of this case is styled as Oracle being the main actor here. So the main strength of Java, I think, is that you could write your code once and run it anywhere. And that was the main thing that Java gave to us that we didn't have before in the marketplace. And it was really a useful feature. And at the same time, what was happening, or at least a little later, we saw the rise of the smartphones, right? We saw the iPhone come out in 2007, I believe. And that really was for a company like Google, something that they had dominated, obviously, the search on the PC platform and, kind of the computer. But we had this new platform out there that the folks who were kind of really thinking about this issue said, well, this changes everything. And that was the smartphone. And so, what we saw was this platform that Java had created or that Sun had created that allowed you to run on any platform. Well, of course, that included on smartphones. And in smartphones, they had their own version of Java. I think it was called Java SE. And so that was kind of a very popular way to create apps on these smartphones. And so, I guess around that time, Google acquired a company called Android. And many people don't remember that Android was not actually Google in the beginning, right? And so that was something that I think Google thought, well, this is the way we're going to go into the smartphone business. And of course, when they got it, maybe they didn't know that it wasn't complete or wasn't as good as they thought it might be. And so they were at the same time also kind of hedging their bets and talking to Sun and saying, well, we want to license Sun, or we want to license Java as well as potentially another alternative to get into the smartphone business. And I think, kind of the evidence of the case has shown that, that the talks kind of broke down with Sun over the fact that, Sun made their Java platform open and available for free to use, but you had to agree to kind of the open source model, which is if you use the code, you're going to have to then, dedicate your code or also follow the open model. And Google didn't want to do that. And so they didn't want to kind of give away their version of what they create using Java. And so talks broke down, and everybody knew what that meant, right? Was that they weren't going to use Java, except that's not what actually Google did. They made the decision that it would be more expeditious to copy some of what was in Java and to, instead of designing their own, they just decided that they were going to take it. So that's kind of the background of the dispute.
So they were actually in talks so that Java was made available to companies and to developers.
I think there were 3 different types of licenses that you could take from Java, from Sun. One of them was the open model. Another was, a fully proprietary model, and you had to pay for that. And so I think, there were business decisions that were being made on both sides, obviously. Mm-hmm. But it was Google that just, kind of made the business decision that they weren't going to license Java under the model that was offered.
And were there alternatives? Could Google have come up with its own alternative if it had wanted to?
Well, that's kind of one of the cruxes of this case, right? Mm-hmm. Was, well, if Google wanted to do this, could they have done it? And one of the arguments that Google has, kind of proffered is that, it was impossible, or nearly so impossible, for them to, once they have adopted, the fact that they're going to use Java, to come up with their own version. And that, I think, is demonstrably false.
In fact, yes, it came out in the through discovery, but there was a very famous and important statement internally from a Google engineer Tim Lindholm, who said to the Android lead Ruben at Google at that time, quote, what we've actually been asked to do, and he was referring to Larry Page and Sergey Brin, the founders and presidents and CEO of Google at the time, is to investigate what technical alternatives exist to Java for Android and Chrome. We've been over a bunch of these, and we think they all suck. We conclude that we need to negotiate a license for Java under the terms we need. And of course, as Tim just described, the licensing negotiations broke down. And you mentioned that they therefore just took the code. How much code did they copy? Did Google copy?
So it's undisputed by Google that what they copied were 11,500 lines of Oracle's copyrighted code. It's interesting, you can say, well, that doesn't seem like much in the context of maybe millions of lines of code that you might have in a smartphone. But the issue is it's not just the lines of code, it's how they're organized. It's all of the creative processes that go into coming up with a system of code that actually works for the users, right? Because I think one of the things that many folks miss is Google wasn't just copying the code to get the code. What they were copying the code for was to get the programmers. Because if you learned how to work with the Java programming language and you were a good developer, and now all of a sudden you are kind of faced with a new programming language that you have to relearn, that is kind of a transaction cost that you have to decide. Well, do I want to learn how to program in this Android operating system that's different than the Java that I actually have spent a lot of my time learning and figuring out? And so what Google wanted to acquire was not necessarily the Java code, but it was the Java programmers. And so that's kind of an interesting spin on what really Google's intent was here.
So they're like copying a book because there's a established fan base for that book.
Yeah, it's like the copy, we talked about this before, the copy of the White Album, right? We didn't copy the White Album to get the White Album music. What we did was we wanted the fan base. Yeah.
So earlier we were talking about the Danger Mouse remixing the White Album, and the reason why he picked the White Album was because it was the White Album. He could have picked some garage band that no one heard of, but then he wouldn't have had the fame and the immediate access to fans that he had by remixing the White Album.
Yeah. At the time, Java was one of the most kind of popular programming languages in the world, and so this was a choice that they made that was was something that brought that group of programmers to the platform. Because remember what Google was really competing with, I think, as a business, at least in their minds, was that the iPhone was out there, and the App Store in the iPhone was out there, and we needed to create an App Store for Android, and so that means that we had we have to create a platform that developers are going to be attracted to.
Speaking personally, I actually had the very first Motorola Android phone, the one with the slide-out mechanical keyboard. They licensed Android from Star Wars, from Lucasfilms. And I remember distinctly that device. I did not realize that I was carrying an infringing device in my pocket at that time. It was Oracle v. Google, because Oracle sued, therefore, Google for copyright infringement. Just very quickly, kind of what happened through the past 11 years of litigation that this ended up now as Google v. Oracle, where Google is appealing to the U.S. Supreme Court?
Sure. So Oracle, sued Google in 2010 based on patent and copyright infringement. The patents were out of the case pretty quickly, and it went to a jury trial, and the jury actually decided that that Google infringed the copyrights. They split on the issue of fair use, and so that decision was first appealed to the Federal Circuit Court of Appeals here in Washington, and because of the fact that there were patents in the case. This is where that decision went. The CAFC said that the declaring code, and this is kind of out of the case, the declaring code and the structure, sequence, and organization of the API packages are entitled to copyright protection, and therefore they reversed the district court and sent it back for a new trial on fair use. So then they went back to the district court and decided fair use. Now that, of course, went to the jury, and the jury this time found that it was excused by fair use, right? So now we get a second appeal to the Court of Appeals for the Federal Circuit. This time, Oracle was arguing that the fair use was not an appropriate decision for the jury. And the CAFC again reversed and said that Google's use of Java API packages was not fair as a matter of law, right? And so they decided as a matter of law that the use was not fair. It was a commercial use. It was a competing use. It was not a fair use.
And so now Google has appealed to the Supreme Court.
Yes.
And this is a really significant case, right? Because the two questions that the Supreme Court has granted review on is the copyrightability of an API,
right,
and whether this copying of the API, if it is copyrighted, counts as fair use. So when was the last time the Supreme Court heard a case on the copyrightability of a software program?
I am not aware.
So this will be the very first time the Supreme Court has ruled on the copyrightability of software programs. I mean, the Congress weighed in 1980 and amended the copyright code and said that a code is copyrightable. So this will be the first time now that the Supreme Court decides the bounds of that statute that Congress enacted. And then the fair use decision, it's been similarly a very long time since I think we last had a fair use ruling.
Yeah.
Probably since the 90s, I think, with...
I mean, copyright has been a really static kind of body of law. I think everybody, and including, if you look at some of the evidence in the case, from the district court, that Google knew what they were doing, right? They knew that they needed a license for their use of Java, and that they intentionally didn't get one.
Yeah. And for commercial benefit, right, for create a competing product, it would seem, at least on its face, not within the scope of what's typically considered fair use, which is like copying a small section of an article to use for use in teaching a class. For instance, when teaching my class, if I immediately find something that I think is relevant and I haven't decided to incorporate this permanently into my teaching materials that just came out recently, I might take a paragraph and put it in there. That I'm not competing with it, but if I continue to use it, I would have to get a license. All right, so anything remarkable that happened in the trial that the audience should be made aware of as of kind of understanding the facts and foundations for what's going to be happening at the Supreme Court?
Yeah, there was actually lots of important evidence, I think, that was excluded by the judge in the trial. Kind of the big things were that they excluded evidence that Android supersedes Java in the markets that Java occupied before, right? So this kind of goes to the arguments that Google has made of interoperability, and kind of goes to the point that this is not really interoperable. You think of something being interoperable as working together, That was not really the intent of Google in this case. And so, there was a lot of evidence that, they were actually, what Google intended to do was to kind of be a complete replacement. And in fact, that's what's been borne out in the market, is that we now have Android, and Google SE is no longer out there for smartphones. So, it's one of those things that I think probably was an important thing that was excluded. Also, Google argued that the one of the markets that they didn't compete with Java on were for, this was just about smartphones, but they fully well knew that their next rollout was going to be to PCs and computers. And so at the time, I think it was the day after Discovery closed, that Google made the announcement that they were going to make this all of Android available as an operating system for computers. And so that evidence never kind of met kind of the review by the jury. And so I think there are a lot of things that even if the Supreme Court thinks that the fair use argument, kind of is fair, let's put it that way, that we ought to be looking at the decisions that were made by the district court on exclusions of evidence that ought to go back, and we ought to be, in a sense, going back and retrying for a third time the fair use issue, and I think get a fair read of all of the evidence that we've seen in the case.
So now the SAS Institute, or SAS Institute, I apologize. SAS Institute is, they're going to be filing an amicus brief in the case?
Yeah. So we have put together an amicus brief and are getting prepared to file it in the next few days. And obviously, one of the things that we talk about is really this false dichotomy that Google has set up in this case that says that there's some distinction, right, between the type of code that they call interfaces, these APIs, that there's some, kind of magical distinction between software interfaces and software in general, which we all, including Google, agree is copyrightable. Well, Congress didn't write the statute that way. What Congress said was software is copyrightable. Full stop. Code is code. It's all, kind of somewhat functional because it operates a machine at the end of the day. But it doesn't mean that it's not creative just because it operates on a machine. All software operates on a machine. There's no, kind of logical position where you can say that one type of code ought to be treated as not copyrightable and another type of code ought to be treated as copyrightable. And do we really want, for as much respect as I have for the judiciary, do we really want judges kind of making those fine distinctions? As I said, kind of before, there are, generations of different types of software that are out there, that kind of build on one another, that even under the current rubric that all of this is protected by copyright, we still see massive advances. And so all of these kind of the sky is falling positions that we see from the folks that generally are open source folks, which is philosophically a different way to look at the world with respect to copyrightability. What we see is that we've had a really good, robust software industry here in the United States. It's much more robust than many other places around the world. In fact, all other places around the world. And we've done it under the copyright regime that we currently have. What Google is looking to do here is disturb, all of those years and all of that experience that we have, created this really robust software industry.
Yeah. I mean, the U.S. took the lead throughout the entire world in first extending not just copyright protections, but patent protections as well to computer software programs in the 1980s and 90s. And we are living the results of this now with incredibly strong high-tech industry in Silicon Valley and incredible new devices and products and services brought to us. We all can share our cat videos instantaneously from the supercomputers we have in our pockets that we call phones. My children will never know that a phone used to actually just be something that you could talk to someone with.
But also we're also making medical advances, with using our software, that we wouldn't be able to detect cancer the way that we're detecting cancer using artificial intelligence that SAS has created. And so all of these investments that we make in, making sure that our software product is at the cutting edge, requires capital, and that requires in a proprietary, business model that we have chosen to be in, it requires us to charge for the value of our software.
Let me follow up on that real quickly, because this is, I think, a really important point that people, there tends to be a narrative that it's easy to code. Oh, Flappy Bird. Anyone can make that. It just takes a couple hours and you can make millions. So how easy is it to first write and develop 11,000 lines of code that is then used as the interface program for lots and different developers and programs?
Well, for that, let's look at Java for a second, and let's put ourselves back in the early 1990s. Right?
Ancient times.
Do you remember Microsoft Windows 95 coming out and being that, kind of really, this is the time frame that we're talking about here. And, the folks at Sun were starting from scratch. And so how do you create a software programming language and infrastructure and system from scratch? Well, what you do is you write you come up with the first functions that you're thinking about. Well, this is what the system needs to do, right? It might be print, it might be, figure out how to get data into the system. It might be how do we process data, and how do we print it at the end, right? Or how do we create files at the end? Things that kind of are the crux of the how a computer operates. Well, you have to figure out the language that you're going to use to convey that to the users so that they can develop in your programming language. And so you have to kind of come up with those ideas, and you have thousands and millions of different just things that you can consider as alternatives in that. And it's a very painstaking and kind of creative process, even with the simplest part of that system. And then when you say, okay, well, now we're not just one person writing the code, but we're going to be a team of 10. And we're going to figure out, okay, how are we going to put this all together so that not only can we create something that's going to be a cohesive whole, but we also have to keep our minds focused on who the users are and how the users are going to perceive it. And so it's a very creative process. It's extremely difficult to do. And by the way, when you say, okay, now I'm not only going to do that today, I'm not going to start with this core, but now I need to make it extensible. I'm going to have to think about going into the future and creating, this system that over decades now, 2 or 3 or 4 decades, where we're going to have to make these selections and choices that make our users want to use our system. Remember, Java became very popular, right? That means it was a really great interface, right? The programming language that they created, the structures that they created, all of these interrelationships about, thousands and thousands of different choices that these developers could make over the years. It's a very creative process, and one that lends itself to copyright exactly, right? Copyright protection is to protect the creative expression of the authors of the work. And whether you have an author that sits down and writes a novel, or whether you have 10,000 authors that work for the same organization that create this programming, structure, it's not only a lot of work, but it's a lot of creativity that goes into it. It's not maybe the same type of creativity that you see, a novelist have, but there's so many similarities that that it's really remarkable how consistent it is with the way that that novelists work.
Yeah, this is something I often struggle with, is that you don't have this kind of sharp divide between kind of the innovation industries, engineers and scientists, and creators and artists. I mean, in fact, we understand this already implicitly in our language. Engineers talk about the elegant solution, that innovation is creative and creativity involves innovation. The two often go hand in hand.
Why is this, the way that an Android phone looks, yeah. Right? You think about kind of famously Steve Jobs saying when he came out with the iPhone, right? I don't want any buttons on it. Well, that's really difficult. If we were talking about a different company that came up with the smartphone, I kind of cringe to think about what our smartphones would look like. You
mean if Dell had done it? First it would be beige.
Listen, I am not.
Box.
Dell is a fabulous partner of SAS, and we love Dell.
Yes.
So it certainly would be beige, I imagine. Yes. But I really, there would be, and again, not talking about Dell, but you think about some of the engineering companies out there, there would be antennas. I'm sure involved in our smartphones that would be visible, right? That would catch on our pockets and things like that. Well, it's the same thing when you're trying to create elegant code. Code that people remember, code that makes sense to solve the problem that they're trying to solve. But that doesn't mean that there's only one way to do it. There are a variety of ways, and you make those choices. And that's in and of itself what's creative.
And what you're describing is not just creativity, but thousands, if not tens of thousands of work hours that are going in.
Yeah, it's massive.
What you were describing is occurring even before beta testing, before you're sending it out to consumers and asking them what do they think, and then does it actually work for their intended purposes.
Well, and then there's an iterative creative process that happens after. Yeah. Right? Because the iPhone didn't always look like whatever this is, I'm not sure. It came out and had iterative processes and came up with a device that seems like it's pretty stable now, but it's always going to change. Yeah. And so you can think of the software interfaces as the same thing. The SAS software interface changes and evolves, and gets more, productive and gets more efficient. And all of those things are creative choices that we make.
So it's not, so, I mean, correct me if I'm wrong, but then the argument seems to be being made by Google that you created this, not you directly, you, Oracle, created this incredibly successful program. You invested all this effort and time and created this amazing product, which is what intellectual property does, incentivizes people to create products and get them in the market. And it's so successful, you should lose your IP protection. It either shouldn't be copyrightable, or if it's copyrightable, we should have fair use in copying it.
Yeah, I don't think I can add anything to that.
Yeah.
I think that's exactly what.
It seems to turn IP, the whole point of intellectual property, to bring successful products and services to market in both the creative industries and the high-tech industries, on its head almost.
Yeah. And I think we have to be very concerned about, not only what this case does to copyright law, but also, all of these copyright, or let's say, all of these legal regimes that companies have operated under for now 4 or 5 decades, relating to how we license our software to our users can be disturbed. And so it's actually contract law that is going to be impacted by this decision as well, because if there is no copyright, then what do our licenses prohibit?
What can they prohibit?
What can they prohibit? And so that's a really interesting question, I think, that ought to be something that the Supreme Court looks at, very with jaded view here, that we really are disturbing something that has been stable, and not only the proprietary model. But if you look at the open source model, how do they distribute their code? They distribute it under a software license agreement. If there's no copyright, how do you enforce the provisions of your software license agreement? How do you keep people from just kind of wholesale copying your work and going forward with their own? And the answer is you can't.
So I'd like to take the moment now to open it up to the audience for questions. There will be a microphone available. I see first in the back, and then I see in the front too. Yeah.
Yes, my name is Roger Cochetti, and I have a couple of questions, and I think you've done a very effective job in presenting your position, but two things I hope you could go back on. First of all, what happened to the patent infringement issue, which is it was dismissed early on and was never resurrected? And secondly, if the case is as clear-cut as you're describing, how could a jury have found twice that this was fair use? I mean, it almost sounds like you were saying, I stole the book, and once I got it, I talked the jury into saying that I could do whatever I want with it because it's fair use. So maybe what I'm really asking is, what are the arguments on the other side that would persuade two juries to say, this is not infringement, this is fair use, even though, assuming you've said everything accurately, it was indisputably copyrighted. Fair use is not, there's a long history of fair use. So how does this fit into fair use, I guess, is the real question. And then lastly, how are other technology companies coming down on this issue? What other Amicus, and why are they taking the positions they're taking? Thank you.
We can, 3 questions. I apologize. They're great questions, but I want to make sure we leave time for questions for everyone. So just feel free to just quickly answer the ones you wish to answer.
Sure. So the patents were dismissed. I don't know why they were out of the case. They're completely separate from the copyright claims, and so these are independent claims. On fair use, the jury actually the first time deadlocked on fair use, and so it wasn't a decision by the jury. The second time, they did find fair use. I think that was generally, because that they did not get all of the evidence that I think was, excluded in the case presented to them. And I think the Federal Circuit was right that the commercial use and the commercial nature of the use and the replacement, not, they call it interoperability. Google calls it interoperability, but it's really the replacement. I think that from a legal position that's, cuts so far against a fair use decision that, that it probably wasn't the right decision by the jury. So, but, I don't want to kind of get into disturbing jury verdicts,
But with the mention, it was interesting you mentioned, the jury agreed that there was fair use. I mean, and a very successful narrative has been created around that this is about, what Oracle is really trying to copyright is the functionality of the interface, of the computer interface, which is long-standing copyright doctrine. You can't do that. But I think as Tim has explained, that really it was the 11,000 lines of code that Google copied that was at issue. But you mentioned the book and fair use, and this kind of reminded me of the Google Books litigation, where fair use prevailed in that case. And are there any parallels here between this case and the Google Books? Do you see?
Well, I think that it's similar, right? If you had told me back before the Google Books case, right, that it would have been okay to just go through the library, public library, and get a bunch of books and scan them in, and kind of do what Google had done, I wouldn't have thought that would have been a close question of fair use. I mean, I think that, it was a kind of a twisted decision at the end that ended up there. But the philosophy, I think, is the same behind it, which is we're just going to do it, and and that's a business decision that's been made. And I think when you're that's the job and the role of the courts, right, is to say, when those kind of business decisions are made and it's kind of anti the current copyright regime that we have, it's for the courts to correct those problems.
All right. In the front here, and then I see the back. And I just want to emphasize again, ensure that your proposition ends with a question mark.
Hi, Bruce Guthrie. You mentioned there were 3 types of licenses,
Mm-hmm.
and one of them was proprietary, so they could have actually paid, I presume, to have their proprietary system. The decision not to do that, you're saying, was a business decision. How expensive would that have been? It just seems kind of crazy because Google has some money.
Yeah, and thank you for that. I don't know. I have no idea what the economics of that was at the time, but I imagine it was probably an expensive license.
Well, by the way, the same point was made in the Google Books litigation. The publishers and authors said, you could have come to us. We would have licensed you. We're happy to have people read more of our works through proper licensing practices, and Google just made the business decision, well, no, we'll just copy the works and sue you and impose upon you the cost of suing to try to enforce your rights. So it's a practice that's been recently identified in the IP space as efficient infringement, where a company makes a business decision that it's cheaper and easier for them in the short term to just infringe an IP right and impose upon the IP owner the costs and difficulties of suing them to obtain remuneration. So, in the far back.
Assume for a moment that software had been patentable, not copyrightable. How would that have changed the competitive landscape in the software industry? Would it have been better?
Well, software is both patentable and copyrightable, and I think the way that I at least look at it is, the patent protects the inventions, right? And the copyright protects the creative expression of the authors when they created the code. So that's, and when they created the sequence and the organization of their code. And so really the regime that we have now is both patent and copyright. And it's, it's not just software that, has multiple ways of protecting something, some piece of intellectual property. But it is interesting, again, that kind of given all of these different protection schemes that we have here in the United States, we still have the most robust software industry in the world. So something's working is kind of my point, and we should be careful before we disturb it.
Yes, that's so true.
Yes, my name is Joel Hetker, retired government. Two things come to mind. Look and feel with Samsung and Apple, that went on for years, and only the lawyers benefited. And in JSTOR, the guy committed suicide. Was his name Schwartz or something like that? And then the government reversed the decision. That was on articles in science journals. So look and feel, I mean, that was very vague. This is a much more precise argument. And you have the correct sense of this. When I was a contracting officer, I dealt with SAS. They always wanted the software maintenance up front. Everybody else paid in arrears.
Well, thank you. And, I think, thank you for being a customer. I appreciate that. SAS is a great company that, has done a lot for the uses that our customers make of our software are just phenomenal. And we really love our customers. And, I think in order to continue to become kind of one of those customers or companies that is on the cutting edge, this is what we need. We need an ability to determine what our business model is. It's really for us to determine that, I think, once we figure out that the legal framework is what, how the legal framework that we're left with allows us to make those decisions and choices. What we're seeing, I think, in this case is an organization that is not a tech company. Google is not really a tech company. What they are is an advertising company. And so they give away their tech, right? They give away their software that they develop. They give that away for free, except, of course, for their search engine, right, that they completely control and lock down. So their valuable stuff they keep, but they also make their money on advertising. There are a bunch of other companies. I think the gentleman here asked about, well, why are other tech companies kind of like Microsoft and Amazon supporting, and I don't know if Amazon has come out and supported Google's position, but Microsoft and IBM and Red Hat have come out and supported Google's position. Well, why is that? Well, they don't make their money on their tech either. They're changing into cloud services businesses, right? And so you see how they're making their money is charging for compute cycles in their big cloud services facilities. And they, and kind of speaking about Microsoft, I mean, they make their money not distributing their software anymore. It's all in the cloud. And so they're kind of charging, you might all be paying Microsoft $99 a year for access to their, kind of suite of software. Well, that's a very different model than actually, kind of charging for the software. You're charging for the access to the software, and they're getting compensated based on the cycles. So software has kind of become the content for these big cloud service providers. And if they can get the content for free or for a reduced price, boy, isn't that great? Wouldn't Netflix like to have Disney for free?
Yes, right there.
Hi, thank you so much. In regards to, let's assume that this case weighs on the side of Oracle. How will the tech field, change per se? Obviously, you're bringing up that if it goes in the side of Google, for example, all these large corporations are able to use this for free. But on the inverse side, how is this weighing on the side of Oracle with, more stringent copyright, preventing these corporations from just copywriting all of their lines and therefore limiting the field altogether, making it only a couple organizations? And since we're going into the metaphysical and technology being the future, how is that going to prevent upcoming actors or young entrepreneurs from pursuing this?
That's a great question. I think that that what we're really doing on Oracle's side of this equation is kind of preserving the status quo that we have always seen in industry, and you haven't seen any lack of innovation in the software industry as a result of the current, kind of intellectual property rubric that we have in software. And so the change is really on the side of Google. If you really want to disrupt an industry, say that software, any type of software is uncopyrightable, I think that would be a change that would really disrupt, not only big businesses, but it's hard to see how, what the industry looks like after that kind of change, although, I would expect that we would see the big companies get bigger.
I mean, just to also reemphasize the great points that Tim just made. I mean, we've had robust copyright protection of all code. All written code is automatically copyrighted, and robust patent protection for the past several decades. And what this has facilitated is all of the myriad business models and different approaches to distribution of products and services that we have. And it's why our innovation economy is so strong and vibrant. It's not because IP serves as a lockdown. Intellectual property is property, and what is property but a platform from which people then can make choices about how they choose to structure their businesses and enterprises, creating disaggregated value chains the way that Apple has, or creating open source business models the way that Red Hat and IBM have. In fact, IBM is officially on record in a legal document saying that patents are actually fundamentally important for open source because of the forced disclosure that patents require. And so you're forced to disclose your code and the way that your software functions. And so intellectual property doesn't lock down is the way you were characterizing it, although that's a very common thought, the way that people think of this, and that's how we experience it socially because you hear of the lawsuit, the infringement lawsuit. But really what it facilitates is, and as the Department of Commerce and many other studies have shown, is trillions of dollars of exchanging hands between business persons and innovators and startups obtaining venture capital funding. Something that Google doesn't often talk about much is that they received a patent on their original, Sergey Brin and Larry Alexander received a patent on their original version of their search algorithm back in 1998. They used that to obtain venture capital financing. We all see this on Shark Tank every week. What's the very first question that's asked of the presenter by the venture capitalist when there's a product that they like? You have a patent on this, right? And when they say no, they're like, what? You just went on national television and gave away your entire idea. Why should we invest in you, right? So I just wanted to touch on this a little bit. Yeah. Your response was perfect. But.
Well, thank you. I think also, when you look at a business like IBM Red Hat, they've come down on Google's side by saying basically that you could protect these interfaces by trade secret, which is really interesting, right? Because how could you create an interface that's supposed to be used by people who don't work for your company, your customers, your developers, and folks, and protect it by trade secret?
Yeah.
I'm astonished.
Yeah. Which, by the way, that's how Google has made so many changes to its search algorithms since it first invented it, or at least Larry Alexander and Sergey Brin, that's how they protect their search algorithm right now. It's a trade secret, and they protect it very vehemently, as Tim mentioned. That's the key to a lot of their income as an advertising company. Is there another question over here? Oh, it's not working. Do we have? Okay, speak very loudly because it's being recorded.
If Google had copied those 11,000 lines of code from Sun Microsystems before it was bought by Oracle, would there have been a case?
Yeah,
Can you
so
repeat the question just to make sure we
so-
catch it? Yeah.
exactly. So the question was if Google had copied the 11,000 lines of code before it was bought by Oracle, would there have been a case? And the answer is yes. I think that's actually factually the way that this happened. Was the transition to Oracle happened after the copying occurred. So yes.
Is there anyone else? No? Excellent.
So to circle back to the topic in your amicus brief about how Google is kind of creating this artificial distinction between APIs and just plain old software that's subject to the Copyright Act. So we haven't seen this court decide a copyright case, but we have seen it decide cases involving new types of technology. And a lot of those cases, like for better or worse, the decision does rest on those various distinctions between types of technologies. I guess Carpenter versus United States is probably the more recent, more obvious example, saying, self-site location data is different than other types of data, therefore the doctrine applies differently. Do you think that, and I know it's really hard to read the tea leaves in these scenarios, but do you think that a lot of it at the end of the day will come down to whether or not the judges, at the end of oral argument or before writing their opinions, just think of APIs as plain old software and then apply a textualist interpretation to that? How instrumental do you think that distinction will be?
Well, I think that's the fundamental question in the case. Is there this artificial distinction between API software and other software? Again, kind of going back to my, there are versions of, types of software systems, third generation programs, fourth generation programs, and on and on and on. They all build on each other. And to say a certain class of software, a certain part of that software is unprotectable and other parts are, when Congress has so clearly said software is protectable. It seems to me like that would be a very difficult kind of distinction to draw. And, I think in this case, if you look at the creativity that goes into creating those user interfaces, in many cases, it's more creative than the code that we're saying is the stuff that everybody agrees is copyrightable. In fact, there's this, the kind of the max, if you go in and look at the actual briefing, you'll see Google relates to this kind of max example where it's, give us the maximum value of between two values. That's what you're going to return. And this is one of the functions that they say. Well, the math part of that, right, which is compare two numbers and return the larger, is not that creative, right? The structure that the sequence and organization and structure of what we call the declaring code, the API part, is very sophisticated. And we all agree, yet we all agree that the code that is not as sophisticated and probably far few choices exist for is copyrightable, including Google. And so, to me, it's really a pretty simple, decision here that Congress didn't make distinctions between these two different types of code. This is merely hindsight, good lawyering, or at least the best lawyering that we can do to basically paper over the business decision that was obviously made here to violate software license agreements.
Yeah, great. Oh, wait for the mic. Great, thank you.
So, not a technologist, but wonder what are the practical business implications for Google if they were to lose this case in terms of like the current usability of their products? Like, what happens if the status quo changes?
Sure. The ultimate outcome of the case would be, I suppose, damages. I don't know whether, I imagine there's a possibility, right, of an injunction in the case of intellectual property. Now, of course, that would be, kind of yet another element of decision that would have to be done by the courts and the courts of appeals and things like that. But what I would expect to see is that Google would, relent and pay Oracle a license fee.
Right. I mean, and even if there is an injunction issued, the function of the injunction, especially between two corporate actors, is to then have a license agreement reached between them, which is what happens 99% of the time. The injunction is not the end of the story. 99% of the time, the injunction is the beginning of the process, which should have begun 10 years ago, when the person says, "Okay, now let's have our business discussion. Now let's create the license agreement that you should have created." So I expect there will be damages from the past, 10 years or so of infringement, but then they'll enter into a license going forward. Which is very common and typical.
The other thing that might happen, and I'm kind of remembering, but I'm not, you can't quote me on this, but that Google has already fixed the problem. So, going forward might not be an issue. In fact, they protest that it can't be done. Well, there are examples of kind of these APIs being rewritten, and Spring is one of the things that Oracle itself created an alternative API to the Java, the code involved specifically in this case. So I think that there are certainly ways that Google could, and may have already adjusted its business going forward.
And I'd like to follow up on the question that was asked earlier about kind of the courts making distinctions, because you've talked about how if the court rules in favor of Google, it would unsettle established legal and commercial practices. Also, kind of, what do you think going forward, just as a legal matter, if the court starts making these types of distinctions under the Copyright Act as to what counts as copyrightable and what doesn't, that you don't see actually in the statute? What does this do in terms of the stability of the law going forward? Well, we see lots of cases where people are trying to say, well, this time, this is different. This is, yes.
I think that's the likely state of affairs going forward, is that we will see things that we think are easily copyrightable, come into question because, I don't know if you have seen, there's a clock in the Westin in Alexandria, right, which is right near the patent office, and the clock is a work of art, but it's also functional. And so, is that functional, and so is that copyrightable, or is it a work of art, and is that copyrightable? So, software code is both functional and it's also a work of art. And that's the thing that I think we should leave folks with. Yeah.
So, well, thank you all for coming to this. Thank you very much to Tim. This was it's an auspicious date, not just because we had the benefit of hearing from Tim about the nature of this case and what's really happening, but it's also, for those who may not know, the anniversary of the patent issuing in 1990 to Irwin Jacobs and his colleagues on his invention of the CDMA technology. For those of you who don't know what CDMA technology is, that is the 2G, 3G, 4G, now soon to be 5G digital transmission technology that makes all of our smartphones smart. He's also one of the founders of Qualcomm. So today is an auspicious date of innovation and innovation history. So, but thank you again to Tim, and thank you. It made sense you started talking about the birth of the smartphone industry. So, but thank you to the audience for the great questions. Appreciate it.
Thank you.